past the punch.
It's 9 a.m. We are
I know, it's 9 a.m. for all of us.
Only I have to be up here. You guys just get to sit there and absorb it all, like little sponges. All right, service and process, this is super easy, right? Really easy. Maybe I'll even get you out early today. But first, let's talk about it. But first, I'm not making any promises. But first, let's talk about what you did last semester, because from my conversations with Professor Abramson, maybe there need to be some slight tweaks to the syllabus. Who did a whole bunch of discovery stuff last semester? Did you draft discovery requests? Do you remember? I know it's been long, long ago.
We did a quick interrogatory.
You did quick interrogatories. What,
Yeah.
You didn't require. You didn't do requests for admissions, or did you? Didn't draft anything in that class?
We
There's a multiplicity of answers on that. Yeah. Drafted questions in Abramson. Were you McNeil?
No, I was in Abramson.
You were Abramson. Okay.
No, with McNeil.
No, with McNeil. Did you cover discovery with McNeil?
Very
Yeah, a little. Okay. I mean, it's most. I have a bunch of it baked into the syllabus. Okay, I have a bunch of discovery stuff baked into the syllabus
Great.
this semester. Okay? Yeah, that's good. I'm glad you're excited. We can change that, but the reason I've got it in there is because that's a lot of what you're going to be doing when you're litigating, right? If you are litigators. Those of you that have done some summer work at a law firm that does litigation probably already know this. Because one of the worst things you can do is sit and answer discovery all day long, and then get up the next morning and answer discovery all day long, and then get up the next morning and answer discovery all day long, right? But it's good to know how to do that stuff. So I can dial back if that's what you guys want is you feel like you got it, and you understand how that is all supposed to work, then, you know, at least to a degree, then okay, we'll back off some of the discovery stuff and get into more of the bar prep topics. If you don't want to do that, we can do more discovery. What do we think?
At least some discovery.
No, we're going to do some discovery. Now, you're not getting away
There's a
from this
lot of
completely.
that goes into discovery, and probably wouldn't hurt to have at least a bit of a refresher.
Yeah, I mean, there's deposition stuff, there's requests for admissions, there's interrogatories, there's requests for production of documents. Does everybody know what all that stuff is? Okay. Yeah, as long as you have some sort of baseline for that information, that's good. Okay. Who would rather do more bar prep stuff than discovery? Who would rather do more discovery than bar prep stuff? You guys are no fun. Fine. All right. So I'll change that around a little bit. Huh?
I abstain from voting.
You abstain? All right, thank you. That's notable. And what about the trial practice stuff? I know there's a whole separate class for trial practice, which is why I didn't put a bunch of that stuff in there.
What would that even?
Right?
What is that?
Like voir dire and jury instructions and directed verdict stuff, that kind of thing. Stuff that you would actually be doing at trial. How many of you want to be trial lawyers? A few? Okay. Let me rethink that one. Okay. How many of you intend to take trial practice? Or be on the trial team? A few? Okay. All right. Not a whole lot of interest because you know that you end up never trying a case, right? You know, everything sells. All right. So now you have drafted this complaint, this masterwork that we did last Friday, and you are ready. You are ready to litigate and make gobs and gobs of money as a plaintiff's lawyer. Sorry, it's not fun. Okay. Somebody had a question? No? Yeah, okay. So you got this complaint, and now what are you going to do with it? Just start litigating, propound discovery requests, schedule depositions, that kind of thing? No. We're studying service of process. Welcome. We're studying service of process. And what that means is you've got to get that complaint that's now in its finished form and deliver it to the person you are complaining against. But you can't just deliver it any old way. You can't just throw it in an envelope, slap a stamp on it, and hope it gets to the right place. You have to serve the defendant properly, okay? That's what this is all about. And it sounds pretty simple, right? You've got this thing that sits on top of your complaint called a summons. Has anybody ever drafted a summons? Oh, good, a few of you. Good. Well, federal summons, like most things federal, you can retrieve right off that federal court website. This is what it looks like. Okay? Not that. Back. Okay, Alexa. This thing, right? Simple form that you fill in. Plaintiff, defendant, name and address, et cetera, et cetera, et cetera. Has to be issued by the clerk. Proof of service, this all gets filled out by the person who served. Good to look at those. We'll look at those in a little more detail in just a bit. Serve that along with a copy of the complaint on the defendant. Who gets to serve it? What does the rule say about who gets to serve a complaint? Did you read the rule? Yeah, go ahead.
Could be either yourself or especially appointed by the court.
Not quite what I'm looking for. Go ahead.
I thought it had to be a clerk.
What does the rule say? Who can serve it? Now, the clerk has to issue the summons. Don't get confused about that, right? You go back to Rule 4A and B. The clerk has to issue the summons, right? So you don't get to just fill out your own summons and sign your name where the clerk's name should be underneath the signature line that says clerk. Neil?
Isn't it any non-party that's allowed to be
Anyone is what the rule says. Anyone that's not a party, right? Let's look at the rule. Sometimes the rule is helpful. Right? By whom? Okay. 4C2. By whom? This rule is one of the more comprehensive. Any person, right, who is at least 18 years old and not a party. You're suing someone, you can't just walk it over to them and say, here you go. You got to get somebody else to do it. What's the reason for that, do you think? Why can't a party serve? What do you think might be the rationale that underlies that?
Fight.
What?
A fight.
Well, a fight, yes, that's part of it, yes. Think about if there's an issue of service, think 2 or 3 steps in the future, right? Think if there's an issue with service of process as to whether or not it was properly effected, right? Yeah,
If a defendant could say that it wasn't served properly.
that's right. Yeah, that's right, that's right. And then it's party A against party B on the issue of service of process along with everything else, right? Don't want that. Want a neutral third party with some kind of serve complaint. And what's it like to be a process server? Are there people who make their living just serving process? Oh, yes. Yes. So if you're disenchanted,
That's Chad Johnson.
Take it right now. What are you doing?
That's Chad Johnson.
There's a Montague Grant. I'm your president. Can you please serve your father with those papers? I think they got a good time.
So they're just giving him the lawsuit, right? With these summons on top. That's what they should about clerk. That's what's happening.
you gotta serve on the air. That's fun.
Absolutely, man.
All right.
Talk about the predators and keep it moving.
All right, stay right.
Compliance, by the way, in a divorce practice in particular, but in a compliance practice overall, can get really nasty about this stuff. I want you to make sure that he gets served with this complaint when he's having Thanksgiving dinner and they pull out the cranberry sauce. I mean, like that they get really, don't fall for that. Just get it served the right way. Don't fall into any sort of vindictiveness trap. It's going to lead to violent outcomes. But of all the times I've had somebody served with process or a subpoena or anything like that, I don't remember any instances of violence. I really like this guy. Have you seen this? Really good. That's it. He's served. There's a photo with the process server showing if there's ever any question as to whether or not he's been served.
What happened? What'd you do? I gave him my summons to appear in court.
Why? What's the charge?
It's not a charge. It's he's not paying somebody, so I don't know.
Not paying somebody else?
Yeah.
So did you really have to buy those shoes?
No, I didn't have to, but I bought them anyway.
It's a good
All right, so that's the life of the service, a process server. More or less fun than being a lawyer. I don't know. You decide after 10 years of your career. How does this thing get served? What are the proper ways in which you can do it? Well, we know that just plopping it in a regular old envelope with a forever stamp and sending it to the defendant's address, last known address, that's not going to do it. Okay. So what do we do? Well, the federal rule E1, 4E1, I should say 4E1, says you follow state law for serving summons in an action brought in courts of general jurisdiction in the state where the district court is located or where service is met. Okay? Translate that to English for me. What does that mean?
Just do what the state says
Do what the state says, and how do you find out what the state says?
in their rules
In their rules
of civil procedure.
of civil procedure. I didn't assign it to you. Did anybody look at the Kentucky rules of civil procedure? What do you think would be the analog to, I don't know, let's say, Federal Rule 4A in the Kentucky rules? Have we figured out the conversion table yet? 4, say it again? 4.01, right? Kentucky Civil Rule 4.1. Okay. Let's look at that guy. That's no good. Statutes and court rules. There it is. And this is a helpful guide. I won't read it to you. I'll assume you can read it yourself. But you file the complaint, you get the summons, and at the direction of the initiating party or client, you either, and then it gives you a whole bunch of different ways that you can do this. Right? The most common way in Kentucky, and probably in most places, is certified mail, restricted receipt. Okay? Restricted delivery returns. only one person can sign. That's pretty safe. It's pretty safe. If you want to have it personally served, of course you can do that. Of course you can do that. If you are filing a complaint in Kentucky, in the Kentucky State Court, do you go and use this form on top of your complaint? I wouldn't be asking if the answer was yes. What form do you attach to your complaint? And this nice, neat little package that you're going to send certified mail to your defendant or have personally served. What do you put on there? Hearing some whispers of it, what do you think? So what happened?
The Kentucky version of
The Kentucky version of this, right? Yeah. Yeah. You know how we have the state system and then we got the federal system? And the state system's got its rules and the federal system's got its rules. Well, the state system, federal system rather, has this form and the state system has its own form. Okay? You fill out that form, stick it on top of your complaint, get it served. Right? Simple. Simple, right? Get it served some way prescribed by the means there in Rule 4.01, or 4.02, or 4.03, 4.04, right? Your state Rule 4. Who can get served? Because it's one thing to say, serve the defendant, right? You put that complaint in the defendant's hand personally, that's fine. But human beings are involved here, and you may not always get to do that. Or he says you can deliver it to him personally, or you can leave it in their dwelling or usual place of abode, which if you did the reading, you know, usual place of abode kind of means usual and kind of can mean unusual, with someone of suitable age and discretion who resides there. Just a quick pulse check on this. How do you know what someone of suitable age and discretion, what does that mean? What's suitable age? The rules tell you? Do they?
Rules tell you, like, sometimes it's 13, sometimes it's.
I don't think the rules say. Right?
Is it in common law?
Well, I think you can look at the case law for whatever jurisdiction you're in. Okay? Look at the case law. Look at something. Some other outside source, right? All this stuff, remember, think back to your first year writing class, all this stuff matters. Every last little clause of each one of these rules can be the subject of quite a lot of research and law review articles. Who's on journal? Yeah? Okay, great. Not enough. Suitable age and discretion, what does that mean? Well, we gotta look it up. Who resides there? What does that mean? Now we gotta look that up too. Okay? Make sure you know what it is you're doing, what it is you're getting into before you try to serve this complaint. Because there's lots of ways to do it wrong, as you know, if you did your reading for today, right? Delivering a copy of each to an agent. What's an agent? How do I know what an agent of the defendant is? Show up, give it to the defendant's secretary, and think, oh, okay, that was an agent. Good enough. Yeah. Neil, you got anything?
Oh, I was just going to say one license.
Yeah, well, yes.
Every corporation has a registration process.
Uh-huh.
If they're not in the state, then you can get the Secretary of State registered.
You can, yes, that's right. Yeah. In Kentucky, and that's different from state to state. Okay. So watch out for that. Yes. You had your hand up.
I was just gonna say, you can just go to the Secretary of State's website, search the organization.
Yes. Yeah, yeah. So when you're talking about individual defendants, that's one thing, right? Okay, so this will allow you to serve an individual defendant's agent. Somebody that has an agency relationship with an individual defendant if your defendant's an individual. Now, if your defendant is a corporation, as it often is, then you've got registered agents for service of process. How do we find out who the registered agent of service of process is? Well, as you said, look on the Kentucky Secretary of State's website. Okay? And that's true in most states. Right? That's true in most states. You'll have some listing on the Secretary of State's website of business filings or business records or something like that. You go on there, you click on the business that you're trying to stick it to, and it will tell you who the registered agent is. Super important stuff, not contained in your book, right? You're getting your money's worth this morning. Isn't this fun? Okay. Waiver. Waiver. The nice thing about the waiver provision, and this is fairly new in the rules of procedure. We didn't have this when I was a wee lad growing up, going to law school. Look at the bottom. I've already gotten out of the code. Somewhere back here. Look at the bottom of your Rule 4, wherever you got it. All the way down, all the different provisions, KLM. Why are you getting this? Right here's the form. Notice of a lawsuit and request to waive service of summons. Okay. And you could just type this up on your letterhead and send it over to a defendant and request that they waive service of process. Now, why would you do that? Let's talk about the plaintiff's incentive to do that. What is the plaintiff's incentive to ask for waiver of service of process? I can think of two. There's probably more. Yeah, Kelly.
Save money.
Well, it might save money, right? Might save money. That's sort of the minor one. What's the big one? What's the big incentive the plaintiff has to have the defendant waive service of process? What? I can't hear you. Oh, no. Plaintiff. We'll talk about defendant too. Again, think ahead 2 or 3 steps. Kelsey.
They can't try and say that service of process wasn't.
That's it. Yeah, you have it in black and white from the defendant that they waive service of process. So there's no more service of process issues that you're ever going to litigate later on in the case. Right? That's important because those are really annoying. Okay? Those are really annoying. Unless you thoroughly enjoyed your reading this week. Reading case law about service of process gone awry. Right? Litigating that stuff usually has nothing to do with the core issues that you really want to litigate and the core issues that affect the parties in the first place. Right? It is the very definition of technical lawyering. So can you put your defendant's hat on? Can you put the plaintiff in a real bind if they don't effectuate service of process properly, even if you know about the lawsuit, even if you participate in the litigation? Can you then come back later and say, oh wait, we didn't get proper service of process? Yes, you can. The answer is yes, you can. We'll look at some examples of that too. What's the defendant's incentive to waive? Yeah.
They have longer to respond.
They have longer to respond. That's the carrot. That's the carrot. What's the stick? What's the stick? Look at the rule. What else might they want to respond? let's say I'm a defendant and I'm like, I just don't want to get served for process. Screw that plaintiff. I'm going to make them really work for it. I'm going to make them hire warning order attorneys and so on and so forth. Yeah.
If the defendant doesn't pay for the defendant's requesting to, and they have to pay for the success?
Yeah, you could be on the hook for some fees as the defendant. You could be on the hook for some fees and costs associated with trying to effectuate service of process. That is the stip. That is the stip. So as defense counsel, you get one of these requests for a waiver, you got to stop and think, is this really worth it? That's the point of this rule provision. Right? I said it was a fairly new rule provision. That's the point. Is because you get too many people that want to play little games around service of process instead of actually litigating their claims. And the rule drafters were like, no, we don't want that. Okay. Make sense? Now, you can still, with your defense hat on, remember that you can waive service of process under this rule, but you can still contest jurisdictional issues. You can always contest subject matter jurisdiction. The ability to contest subject matter jurisdiction never, ever goes away. Remember that from last semester, right? You can always do that at any point in the litigation. That's something important to remember. Subject matter jurisdiction, you can always contest. Personal jurisdiction, this doesn't take your ability away to contest personal jurisdiction either. Just because you waive service of process doesn't mean that you're accepting that the court has jurisdiction over you. Okay. So you may waive without fear, more or less. All right. Defendant doesn't get served within 90 days after the complaint is filed. Then the defendant gives notice to the plaintiff and can do what? You're the defendant, you haven't been served within 90 days. As a matter of strategy, what do?
Motion to dismiss.
You can make a motion to dismiss. And then the court will dismiss the action, must dismiss the action, right? Without prejudice. What does it mean to dismiss without prejudice? Yeah, yeah. Right, yeah. So if you dismiss with prejudice, it means we've adjudicated your claims and they ain't no good. They're going away, right? Take it up with the Court of Appeals. You dismiss without prejudice, then that means you can refile. You can refile the next day. Same stuff. And not have to worry about claim/issue preclusion, which we'll talk about later in the semester. You're not having to worry about relitigating the same things. Right? So, do you have to do it, if you're the defendant, do you have to do this on day 91? Who read the Larson case? Yeah. We'll talk about that in a minute, but think about what happened in that case. And think, as a matter of strategy, as the defendant, put your strategic hat on. Okay? Let's say day 90 rolls around, and the plaintiff's statute of limitations expires on day 120. Okay. Complaint is filed on day 1, day 90 rolls around, defendant is still not served. On day 91, as the defendant, do you then move to dismiss the complaint? Okay. What do you do? See where I'm going with it? Anybody totally lost? It's okay if it's over. The plaintiff's statute of limitations runs on day 120, you file your motion to dismiss on what day? 121. 121, right? So just because, again, the rules give you guidelines as to what you can and can't do. But as defense counsel, you filing your motion to dismiss somewhere within this time frame means the difference between the complaint being dismissed without prejudice and the complaint being dismissed with prejudice. Does everybody see that? Yes. Have I lost any of you? Okay, right? Yeah. And if it's dismissed with prejudice, the plaintiff has malpracticed their case. The plaintiff's lawyer has malpracticed their case. And the claims go away forever. You've done a great thing for your client. However unjust it may be in the grand scheme of things. Right? Everybody understand this? We're good on this, right? Keep going? Yes? So all that sounds pretty simple. What's the catch? The catch is, well, there's case law involved and there's human beings involved and there's all this fun stuff. Particularly when you get into the issues of what state law does and does not allow and the boundaries of the Constitution. Right? Which is the point in Mullane. Somebody tell me the 10-cent version of what happened in Mullane. Quickly, if you want to get out of here early. What happens in Mullane? Yeah, Ryan.
A bank decided they were going to shuffle a bunch of funds around, and they needed to notify the people that had stake in those. I forget what they were called. Those vehicles for those funds, and they didn't want to take the time to look them up, so they just published a notification in a paper in this small print in the back of the paper, and they were like, "We've notified everybody that we're doing this, so there's service of process."
It wasn't just that they didn't want to take time to look them up, was it? What was it that allowed them to do that in the first place?
New York statute.
New York statute. New York statute says you can publish this stuff in the paper, and you're fine. That's it. You complied with the rules for service of process. So I'm sorry, I interrupted you. Go on.
No, it's okay. Yeah, I forgot that part. That was it, pretty much. And then I guess it was Mullane, representing some of the folks whose funds had got shuffled around. I imagine it probably wasn't very favorable to the people whose money got shuffled around. He filed a suit saying that it didn't get adequate service of process under the due process clause, and he lost at the trial in appellate levels. They said because under the New York statute, that was adequate service of process.
What's the balancing test that the court identifies in this case? What are they trying to weigh out in determining how much process is enough? Because ultimately, what they decide here, as we've said, is that just publishing the information in the newspaper is not going to be enough to effectuate service on all these people. And what's the balancing test that they use to arrive at that conclusion? These balancing tests happen a lot in con law. Right? It happens a whole lot, Sarah.
I think the measure we apply is that notice needs to be, or the form of notice, the form of notice needs to be reasonably certain to inform those affected, or where conditions do not reasonably permit notice, that the form chosen is not substantially less likely to bring home notice than other reasonable constraints.
Right, clear as day, right? Yeah. So that's more along the lines of the sort of magic language that we're looking for out of this opinion. Look with me at page 375, third paragraph down. Elementary and fundamental requirement of due process. Notice has to be what? Reasonably calculated under all the circumstances to apprise interested parties of the tendency of the action and to afford them an opportunity to present their objections. Have you guys done procedural due process stuff in con law yet? Okay, it'll make more sense after you do that. Under procedural due process, the basic stuff of procedural due process is that before the government takes something away from someone, that person has to be given two things. One is notice, and two is opportunity to be heard. Okay? Those are the big questions you have. You have a client come into your office and say, look, the government took away my benefits, or the government did this, or the government did that. The first question you want to ask is, was there proper notice? What the government tell you ahead of time that they were going to do that thing that they did to you? And then secondly, did they give you enough opportunity to be heard? Okay? That is, did they listen to your side of the story? That is the basic stuff of 14th Amendment procedural due process. That's what this case is about. And they say those basic requirements aren't met here if you just publish a notice in the newspaper. That's not enough. You got to go further. But back to my original question, what's the balancing test? Because this pops up in con law all the time. What's the balancing test that the court uses to arrive at that? Yeah.
I think it was the individual's due process rights versus how practical or impractical it would be to serve everyone's process.
The interest, this is the basic version, right? The interest of the state in getting business done and the interest of the individual in fairness. Okay? So you're balancing state interests against individual interests. Really, really common in all kinds of constitutional law jurisprudence. What's the holding here? What is the court holding? We touched on it. What ultimately happens? Yeah.
Since it was a binding settlement that for the accounts or whatever, due process was not satisfied because it didn't meet that balancing test.
Kind of. Due process was not satisfied by what, Chad?
Well, it says that they held that the notice of judicial settlement of the accounts by the New York banking law was incompatible with the requirements of the 14th Amendment as a basis for their adjudication, depriving known persons whose whereabouts are also known as substantial property rights.
That's where it says we hold the, right, the very last paragraph of the case, that's where the holding is contained more or less, right? What does that mean in plain English? What are they saying? Yeah.
I felt like for the people that they didn't know, like that were unknown, they said it doesn't matter because it's probably not going to get to them anyway. So publication is fine. But for the people that they had addresses for and that they've been mailing stuff to, that they have to do I can't use the language, but like basically reasonably calculated to reach the interested parties. So for them it was wrong, but for the people who were unknown, they didn't really care because it's not going to reach them.
That's right. And the interesting thing that happens here, though, notice of judicial settlements of accounts required by the New York banking law is incompatible with the requirements of the 14th Amendment. Stop there. Okay. The New York banking law that allows you to just do this in the newspaper is incompatible with the requirements of the 14th Amendment. Therefore, what happens to that banking law? Right? You can't use it like that. You can't use it like that. So that's this is why you get paid $300 an hour, right? There's another limitation on just something as simple as due process, as simple as service of process, that constitutional limitation. So you have the federal rules that come into play in federal action, the state rules that sort of set some parameters for how people can be And then, on top of all that, does the method of service of process prescribed by the state run up against the constitutional problem? And if it does, then that method's got to go. It's no good. Everybody with me? It should be much easier after you take some Tylenol. Right? Much easier. Okay, and then Larson. Really quickly through Larson. What is the lesson? What is the precautionary tale that your authors want you to walk away with from Larson? What do you think? What do you think the point is of that case? Why was it included in your casebook? You know, casebook authors generally include these cases in your book for a reason. Not always, but most of the time. What do you think it's there for? Yeah.
Wanting the parties to be aware of like the statute of limitations.
Yeah.
And that even if the defendant waived process or whatever, like
Well,
still.
There's no waiver here.
Right.
There's no waiver. That does remove the problem actually completely.
Yeah. Well, even if there was, yeah, no.
Yeah. What do we think? What do you take away from this? As a plaintiff's attorney, Seth.
Don't rely on the waive, because they tried multiple times to serve them and to have them, have the man limit waive.
Yeah. Yeah.
And they ultimately ended up going to the sheriff's department. They don't do it, right, like just go to the sheriff's department.
Right, yeah. Should have done that a long time ago. Get that done and over with, get it out of the way first, right? Don't assume, I think the big lesson is, don't assume that service of process is not an issue. Okay? Don't assume that it's not going to be an issue in the future. What's the controlling rule that the court uses to determine whether or not service of process was proper in this case? How did they come to the conclusion? What law did they look at to determine that service of process was improper? Yeah. Minnesota's Rule 4, right? Rule 3. Because everything's annoyingly different, right? See that in the middle of 382. State rules control, just like it would here in Kentucky. How could the plaintiff fix this? Well, we already sort of touched on that, right? Make sure the damn thing gets served. Make sure it's really, really served. And just because the defendant knows about the action, is communicating with you about the action, doesn't mean that service of process has been effectuated. I said it at the beginning, I'll say it again because it bears repeating. Could the court have reached a different outcome here? One that didn't take Mrs. Larson's ability to sue for medical malpractice completely away from her. Because you understand procedurally what's happening here, right? She files the complaint within the statute, exactly the same scenario we were talking about before. She files the complaint within the statute of limitations, and then the statute of limitations expires without the defendant having been served. The defendant moves to dismiss. The complaint is dismissed without prejudice. Can she then just go and refile it? No, she can't just go refile it. Why not?
She doesn't have a claim anymore because the
Statute expired. The statute's gone. So when you've been dismissed without prejudice and you go running back to the courthouse the next day to refile the same complaint again, it's like you're starting over. Right? This is a fresh start. It doesn't count that you filed it 6 months ago. All that stuff is gone. It's been dismissed and it doesn't count anymore. As such, she loses her ability to file a medical malpractice case, no matter how badly she's been malpracticed on. question was, could the court have reached a different outcome? Did they have to say that the case had to be dismissed? Did the court have to dismiss this case without prejudice under these circumstances? What do we think? Who says, yes, the court had to dismiss this case under these circumstances? Who says, no, the court did not? You have to pick a side. Who said, no, the court did not have to dismiss the case under these circumstances? The court has got all kinds of leeway in matters like this. And if you had this in front of 5 different courts, you'd have 5 different results. Okay, 10 different courts, you get 10 different. Or at least 50-50, right? Could the court have said, yeah, the defendant's been participating here, and so we're going to say that this is constructive service of process. They know about this. And so I'll give you 30 days, plaintiff, to effectuate proper service of process, and let's get on with the case. Can the court do that? Yeah, the court can do that. Sure they can. They're the court. They can do lots of things. What if the defendant had answered the complaint? To answer the complaint, you raise insufficient service of process in the answer to the complaint, which you should do if you're defending a case. You know there's an issue of service of process. Raise it as an affirmative defense in your answer. And then a month later, or however long later, after the statute of limitation runs, move for summary judgment based on improper service of process. Can the defendant do that? You mean to tell me that a defendant can lay in the weeds like that, knowing there's an issue of service of process, knowing that service is defective, or at least thinking that it is, and just sit on that information until after the statute of limitations runs, and then file a motion for summary judgment, thereby disposing of a plaintiff's entire case? You think a defendant can do that? Who says yes? Who says no? Sure they can do that. Sure they can do that. Sure. If you've got a judge that's willing to dismiss on service of process issues, again, the biggest rule of all is no by judge. Right? If you think you've got a judge, if you're sitting in the defense counsel chair and you think you've got a judge that's going to go for something like that, you can get rid of the complaint. You can get rid of the whole case. All right. We've already touched on this. Actual knowledge of the suit doesn't mean you don't have to comply with the service rules. We know this. If you look at the notes and questions and other stuff that's going on in your book, you know that someone have more than one usual place of abode. In most jurisdictions, they're not going to just pigeonhole you into having one of those. If you look at Civil Rules 4.05 and 4.07, well, if you look at those 2 rules in the Kentucky Rules of Civil Procedure, that gives you the process that you need to appoint what's called a warning order attorney, which is for when you really can't find the defendant that you want to serve. You see this come up a lot in divorce actions. Anybody ever filed a motion for warning order attorney or done work on that before? Yeah. So that's where those procedures are contained. If you get really up a creek on service of process, you can appoint a warning order attorney and pay somebody to go out and say, yeah, I can't find it. Official versus individual capacities, boy, if you take my civil rights class, which I'm sure all of you will, you'll learn that there's a difference between someone acting in their government official, acting in their official capacity, and acting in their individual capacity. Okay? This is really important for constitutional actions. Was someone acting in their official capacity, or were they acting in their individual capacity? Police officers have an official capacity and individual capacity. The governor of Kentucky technically has an official capacity and an individual capacity, right? The President of the United States, official capacity and individual capacity. Government officials of all shapes and sizes have these. And according to, depending on the rules in your state, you may have to serve a government official in both their official capacity and their individual capacity, which seems stupid. And it's a fantastically stupid legal fiction, I'll grant you. But that's the law, right? Sometimes we got to do things that seem unnecessary. And is it possible to serve someone in their official capacity, but not serve them in their individual capacity, and then have your individual capacity claims dismissed later on for insufficient service of process? Oh yes. Oh yes. Yes. Trust me on that one. What happens, again, thinking a couple of steps ahead into the litigation, what happens if you serve somebody but they say, no, you didn't serve me, and then they go on pretending, it's different from the hypothetical that we talked about before. Assume they don't answer, and they don't participate in the litigation in any way, shape, or form. You serve somebody properly, you're sure it was proper service of process, they still refuse to participate in the litigation. What do? Yeah.
Default judgment?
Yeah, we'll talk about default judgments later in the semester. Move for default judgment. Saying essentially, the defendant didn't answer, therefore we win. We should just automatically win. They forfeit. I'm not going to get you out early, I'm sorry. So then what happens though? You move for default judgment, and they're going to contest that, right? Hopefully. Show up and contest it. Hopefully from the defense side. The plaintiff side, they don't contest it, you get your judgment, you go out and play. The defense says, no, we were never served with process. Then you get into the situation that we talked about at the top of the hour, where you have this sort of pissing contest between people who are saying, yes, it was served, and no, it wasn't served. Yes, it was served properly, no, it wasn't served properly. It becomes an issue of fact for the court to resolve. Okay? Simple as that. Doesn't usually happen. Okay, these problems. Adam sues Burson in federal court. Must or may the process server give the complaint and summons to Burson personally? Let's assume that we are in Kentucky.
Yes.
Yes?
No.
It's not a yes or no question. Must or may? May, right. Yeah, you don't have to. Don't have to. The process server does not have to do that. Right? Certified mail is okay. It might give you more peace of mind to have it served personally, but you don't have to. Problem number 2. A sues B in federal court. A personally takes the papers to person's home, leaving them with a 10-year-old girl. Was service process proper? Give me the chapter and verse on this one.
Is it 4C? 4C2?
4C is one. There's another one too.
E2B?
Yeah, good. Okay. 4C says, it's improper in 2 ways, right? 4C says any person who is at least 18 years old and not a party, right? Not a party, that runs up against the language of the problem. Adams personally did. Leaving them with the 10-year-old girl, probably what caught your attention first, E2B, leaving a copy of each of the individual's dwelling or usual place of abode with someone of suitable age and discretion. 10 years old is not suitable age and discretion, even under the most lax of all trial judges, right? I don't think there's any jurisdiction in the country that has found someone to be of suitable age and discretion to be when you're 15 or 16. Okay, so 10 years old is right out. How about 3? Adam sues person in federal court. Injury, blah blah blah. Process server hands the papers in person. His weekend lakefront cottage in a nearby county. Service of process proper? What do we think? Make your case. Yep.
Was the county still in the same state as the federal court?
Yes. Good? Service is good? Service is not good. I think it's good. I think it's good. I think this is the language here is that we're asking is usual abode. Is this someone's usual abode? So if you're answering one of these, let's say on a final exam, make sure that you throw some of that rule language in there to let me know that you've read the right section of the rule and that's how you came up with your answer. But however you come out on that, I think that a weekend lakefront cottage in a nearby county is probably enough to be usual abode, right? A sues B in federal court, processor leaves the papers with the limousine driver to answer the door at the person's home. Driver doesn't live there. Service good? Service not good? Probably not. Probably not. The driver lived there? All right, everybody see how we got to all that? Questions about service process generally? No? Good? Okay. So, you are still, in the last 15-ish minutes that we have here, you're still the plaintiff's attorney representing McCoy. This time, your complaint is not against Hatfield, but against the bar. It's a dram shop complaint against Wick's Pizza Incorporated in Kentucky. Draft me a summons for the state court. It'll take you, let's say, 45 seconds to do this. Very, very simple. Draft a summons in Kentucky, the Kentucky State Court, not that federal summons we looked at, that properly serves Wick's Pizza Inc.
Leonard.
Yeah, this is not like a complaint. You don't just draft this up from scratch. There's a form that the clerk has to sign on.